Okie dokie then, and welcome to day 2, the real power hierarchy. Foundational lesson. Yesterday, you learned what family court is. Today, you're going to learn about who actually holds influence inside it. Most people walk into family court believing, do believe I've been bombarded, believe the power sits with evidence. That would be at the top of the list, wouldn't it? That'd be definitely top of the list. Facts. You've got evidence, facts, make sense. The law would be up there as well, wouldn't it? And then you've got logic. Now that's definitely there, but obviously logic is more, that varies from person to person. But that belief is, that this is what you'd expect, and it's comforting, right? It's nice. It's a nice thought. It's also wrong. Family court has a hierarchy, but it's not written anywhere, and nobody explains it to you. No one. Because most people inside the system don't consciously articulate it themselves, but it operates all the same. Here is the real hierarchy, stripped of politeness. Number 1, priority, narrative safety, Cafcass opinion, then judicial convenience, then procedure, and then evidence, and then you, the parent. And if that makes you uncomfortable, good, because discomfort means you're shedding another illusion. Let's take this apart for you properly so you can see what I'm talking about. The narrative safety. The narrative safety sits at the top because it defines what the court thinks it's managing. Once a narrative is established, high conflict, safeguarding concerns, emotional harm, risk, everything else becomes subordinate to managing that story safely. Evidence that fits that narrative is amplified. Evidence that disrupts it is treated cautiously, delayed, or quietly ignored. This isn't corruption. It's human systems protecting themselves from uncertainty. Next, Cafcass opinion. Cafcass sits second because it outsources risks. Judges rely on Cafcass not because Cafcass is infallible, but because it allows responsibility to be shared. If something later goes wrong, the court can say, well, that was based on the professional advice. Of course it was, because you haven't got a member of the brain cell, have you? That matters a bit more than most people realize, because I can explain it. Again, it shoves the blame. It just put its shoulders the blame somewhere else, and no one takes responsibility. You then got the judicial convenience. Judges are not lazy, but they are constrained. They manage time. They're overworked. Listings, appeals, compliance, paperwork volume, positions that are clear, structured, and, well, procedurally safe rise. Positions that are emotionally dense, chaotic, or sprawling sink and take a back seat. Then goes procedure. Procedure is the system's immune response. It signals predictability. It signals discipline, and it signals safety. Procedural competence doesn't win cases on its own, but lack of it loses them fast. Then you've got at the bottom, evidence just above you. Evidence matters, but only after the above levers are satisfied. Evidence that threatens the narrative, increases risk, or creates institutional discomfort, well, that will struggle to land, regardless of how strong it is. That's the part people hate hearing. But once you understand this hierarchy, something shifts. You stop shouting facts into vacuums. You stop assuming logic will rescue you. You stop mistaking moral certainty for influence. And instead, you start asking a better question. Where does my position sit in the hierarchy? And what must I address before evidence can be heard? That question changes everything. Right. Practice back, the physical work, the thinking you have to go away and do now, is mapping power, I call it. Seeing the system as it sees you. Today, you are mapping influence, not fairness. You are not answering as you. You are answering as the system looking at you. If you do this properly, you will feel slightly exposed, and that's normal. And if you're feeling exposed, you're doing this properly. Don't be right. So narrative safety, the question is, what is a dominant story the court appears to be managing? This is not what you think the case is about. It is what the system believes it must contain safely. Examples of narrative safety are, this is a high conflict into a relationship, requiring containment. This case involves safeguarding concerns that must be managed cautiously. There is a risk of emotional harm to the child if contact is mishandled. Both parents struggle to communicate. Stability is the priority. This is a volatile situation where gradual progression is safest. Did you notice something there? Did you notice the fact that, and it's really important, this, none of these say who is right. None of them. They define what the court thinks it's managing. Your task now, write one sentence that captures the narrative safety frame currently sitting over your case. If it feels reductive or unfair, that's probably accurate. Cafcass' opinion. Now, how has Cafcass reinforced, softened, or shaped the narrative? Cafcass rarely invents narratives from nothing. They usually translate existing risk into professional language. And examples of Cafcass' opinion, it might be the father appears focused on fairness rather than the child's emotional needs. Mother presents as anxious but focused. There is limited evidence of insight into how conflict impacts the child. Both parents love the child, but communication remains problematic. A cautious, stepped approach to contact is recommended. Notice again, words like appears, limited, concerns, recommends, no findings, lots of risk management. And your task is to write 2-3 sentences describing how Cafcass currently positions you or is likely to position you if they've not spoken to you yet. Do not argue with it, describe it. Judicial convenience. Now, where does your case create friction for the court? Judges value clarity, predictability, manageable decisions. They struggle with sprawling narratives, emotional volatility, constant applications. Examples of judicial friction: multiple allegations requiring findings, repeated emergency applications, large volume of unrestricted evidence, parties who won't narrow the issues, positions that force the judge into an all or nothing decision. Judges don't like that decision, or so they say. You must identify at least one way your case is hard for a judge to manage. This is not self-criticism, it's situational. It's situational awareness. Number 4, the procedure. Now, another one for you would be, what procedural signals are you sending? Procedure is how the system decides whether you are safe or risky to deal with. Positive procedural signals. Now, clear, structured statements, compliance with deadliness, natural tone, focused applications. Negative procedural signals. Rambling or emotional documents. Missed deadlines. Aggressive language. Overloading the court with material that, just material, unnecessary nonsense. Your daily task this time around is going to be to write one paragraph answering if the court assessed you purely on procedure and tone, and what would it conclude? And you have to be honest. And where does your evidence currently sit in the hierarchy of that? This is the hardest one. Most people don't like this one at all. So, strong evidence exists, but it challenges the safeguarding narrative. Evidence supports my position, but hasn't been contextualized for risk. Evidence is present, but fragmented and emotionally framed. Evidence aligns with the narrative and is therefore being relied upon. Evidence doesn't fail because it's weak. It fails because it's misplaced.